And welcome back here to Live Now from Fox. I'm Andrew Kraft. Let's get right to more of these top headlines. An update, pretty big one, on the Epstein-Maxwell saga. This is what we know. According to a judge's ruling today, transcripts of grand jury testimony that led to sex trafficking charges against Jeffrey Epstein's longtime confidant, Ghislaine Maxwell, well, they should not be released. That's according to that judge's ruling in New York today. Fox News correspondent Kevin Cork with more details.
Grand jury records from the sex trafficking case of Jeffrey Epstein's former girlfriend, Ghislaine Maxwell, will remain sealed. On Monday, a U.S. district judge denied the Department of Justice's request to release the material. Judge Paul Engelmayer dismissed the DOJ's argument that the release of those documents would reveal new information about the crimes of Epstein and Maxwell, calling it, quote, demonstrably false. The ruling comes amid growing discontent from a part of President Trump's supporters, some of whom are upset with the DOJ investigation into the Epstein case. And Democrats, of course, are now accusing the president of focusing on other issues to distract from any possible political fallout.
Typical move by this president to create chaos and uncertainty and to draw the attention from other issues like Jeffrey Epstein.
While he's weaponizing government against innocent people, he's bending over backwards to give treatment to the worst sex offender or the worst sexual predator in America, Ghislaine Maxwell.
Before the president's re-election, he vowed to make Epstein-related documents public and also accused Democrats of covering up information regarding the case. Vice President J.D. Vance speaking on the topic on Fox Sunday Morning Futures.
President Trump has demanded full transparency from this, and yet somehow the Democrats are attacking him and not the Biden administration, which did nothing.
Meantime, a separate judge is said to still be considering the DOJ's bid to unseal different grand jury records from the Epstein case as the story continues. In Washington, I'm Kevin Cork, Fox News.
Evan, thanks so much. Let's bring into the conversation a familiar face to you by now who's been helping us and guiding us through this major story. That's, of course, Kalen Deese. He covers the Department of Justice for the Washington Examiner. He joins me. Kalen, thanks for being with us. We had to get you on for this. So now what, I guess, is the question here. Is this a loss for the Trump DOJ today?
Well, it definitely seems like it's a loss from the way that things have been going so far in these transparency efforts that are now being panned, as we see by a judge several times in his written opinion about this. We saw previously there was an effort to unseal some of the grand jury information from the 2000s case against Epstein. That's the one where he saw a 13-month sentence, where he was given a early release after being convicted for having sexual contact with a minor and someone who was around the age of 18. So we see that in that case, we didn't get any information from the judge there. Likewise, with Judge Paul Engelmayer, he's not giving anything related to the Maxwell case. And obviously, she still has a pending appeal at the Supreme Court, but that didn't really seem to weigh too much into his decision-making here. He seemed to be focusing more on this assessment by the DOJ that there was a significant historical or public interest. He said that that argument alone wasn't enough to buy this sort of information give from him, and that he even said further that there wasn't a whole lot of information in the grand jury transcripts that was relevant or new to what the administration was seeking. So definitely we are 2-0 on this. There's one more attempt with the actual Epstein criminal case to get that grand jury information.
So, Kalen, I want to set the scene here because throughout this story, I have asked you, and I have discussed, and I have reported, it is extremely unorthodox and unusual for a federal judge in any circumstance to allow for the release of grand jury material, even if the U.S. government is asking for it. The Associated Press noted that very fact here. They said the district judge here, Paul Engelmayer, he's an Obama appointee, said in a written decision that federal law almost never allows for the release of grand jury materials and that making the documents public casually was a bad idea. Why is that kind of the norm for the federal judiciary here? What is it intended to do? Protect sources and methods, protect victims, what? Why is it so unusual to see grand jury material?
Well, that's a great early assessment of what you were talking about there. protecting things as far as witnesses, people. Well, we know in this case that it was just a couple of law enforcement witnesses in the Epstein and Maxwell grand juries who were testifying. But the fact of the matter is that there were elements of this that involved also victims' names. And we even saw some letters from some of the victims that were of Maxwell and Epstein, who were saying that they didn't want any identifying information to be revealed, although some of them were okay with other elements. But yes, it is something that ultimately there is a reason why these things are kept sealed. There's a reason why it only should be for the eyes of the grand jury, which we know are assembled in secret. But at the same time, we are supposed to have confidence that the DOJ is giving us everything it can, or telling us everything it can, that it is going to provide this information or seek to get the information from the judge. So it seems to me that this is something that the DOJ should have known from the outset.
Okay.
And that's something that federal prosecutors have been saying is very commonplace, that you're just not going to get any judge to let this information be used unless it's going to be for the furtherance of a separate case that gets brought by the government. It's very material use cases. Okay. And that is the end all be all here. Now, we do know that the DOJ has more information that is seized, but that is a whole other story in and of itself.
Yeah. You know, Caitlin, I've been asking you, our legal analysts who come on almost every night for the last 2 months, and I have been asking them time and again, what could be revealed in grand jury testimony or transcripts that was not already divulged and revealed at Ghislaine Maxwell's trial? The judge kind of agrees with that question here. So he said this in his ruling. He wrote that after privately reviewing the grand jury transcripts, he privately reviewed them. The judge said anyone familiar with the evidence from her trial would, quote, learn next to nothing new and would, quote, come away feeling disappointed and misled. He even kind of belittled, that's the term the Associated Press uses, belittling the DOJ, saying that the DOJ's argument that releasing these materials might reveal new information about Epstein or Maxwell's crimes, he called that premise, quote, demonstrably false here. So the judge really kind of going after the DOJ, saying there is no there. This judge is saying that there is no there.
Yeah, and it's something that I think that as we get more into the third and final request here, it'll be interesting to see if there's any difference in the way that situation shakes down either, because that involves a defendant who is now dead, Jeffrey Epstein. But what I think is going to be even more interesting going forward is how this becomes, and already has been for several weeks, a political wedge that Donald Trump's enemies, his foes, Democrats, namely, are using against him, because we've seen even today with a Senate Judiciary Committee minority member, Sheldon Whitehouse, saying that he wants to see everything that went into the DOJ's decision, or I should say the Bureau of Prisons decision, to take Ghislaine Maxwell out of that low security facility and send her to a minimum security facility there in Texas. He's asking the Bureau of Prisons what was the justification for this, because she did not meet the technical, because she had a sexual related felony in her own case, that is something that is usually not grounds for reducing someone to a minimum security. So we're seeing Democrats try to use this more and more as a wedge. And it's interesting, too, that we have that report last week that the DOJ is considering whether to release some of the audio transcript from Deputy Attorney General Todd Blanche's interview with Maxwell, because now it's seeming like that is sort of the consolation prize here. Maybe the DOJ was starting to think to themselves that this grand jury information wasn't going to get out there. So that's why there is that internal debate about whether to release that transcript with Maxwell and whether it's going to be sent to us in full, partial, or even at all is sort of what remains to be seen.
So you mentioned there on Capitol Hill the efforts there to get information on this story. I want to remind the viewers of this from James Comer. He's a Republican chairman of the House Oversight and Government Reform Committee. This was from July 23rd, saying, I've issued a subpoena to Ghislaine Maxwell for a deposition to occur at Federal Correctional Institution, Tallahassee on August 11th. That's today. The DOJ is cooperating and will help facilitate the deposition at the prison. So she's no longer at the prison. This date, this deadline has come and passed here. So what is the next line of attack? What is the strategy from House Republicans, the Trump White House? What do they got next, Kaylin?
Well, it's kind of a disappointment to say that, honestly, there's really an indefinite stall on this, partially because a lot of the lawmakers are there on recess, but also partially because it was Comer himself who said that he was willing to delay any further communications about whether Ghislaine Maxwell was going to come to Congress in light of her Supreme Court appeal, which she is trying to say that she was implicated by the non-prosecution agreement that the feds offered Epstein, that is, in the early 2000s. Now, the Justice Department has said that this is not a valid argument, that the Supreme Court should not take up this case, but it seems to be her last bastion of sorts to try to get her own way through this. If she can get the Supreme Court to take up this case, she thinks that there's going to be some sort of consideration about the scope of non-prosecution agreements. But legal experts that I speak to, they say that is very unlikely that the Supreme Court's going to take up this case. This is during a conference where they routinely deny thousands of cert petitions. So once she gets this possible denial, then she's going to have to start thinking about whether she wants to speak more with the feds, if there's anything that she thinks that could perhaps be leading to a reduction in her sentence if she talks about some people that were allegedly involved with Epstein's crimes. But it gets down to the core of everything that we know about what the DOJ, what the FBI still have. And that is allegations by victims that, without the material given to the public for the public to met out what these victims have said about third parties and giving a full scope of the credibility of what these victims may or may not have, it is sort of a null case. They can't really bring anything to the public without also exposing some of the victims' names, and that's also something that's not going to happen either. So Ghislaine Maxwell seems to be perhaps the last bastion of any information that the public might get going forward.
Kaylin Deason, we'll leave it at that. We could talk about this for the next hour. Got to keep it moving, though. Kaylin, thanks so much. Great reporting.
Thank you.